All right. We are here on Francis Mallory as personal representative of the estate of Sammy Mallory versus Taylor Smith. Is the plaintiff ready to proceed?
Your Honor, before we do, may we introduce ourselves to the court?
Yes, you may.
And may I approach the bench with Team
Yes, if you can get close in any way.
Yes, Your Honor. May I approach the members of the jury?
Yes, you may.
And we do have a few preliminary matters at this time if the court would entertain those.
Okay.
May we freely move about the courtroom with respect to the podium?
Absolutely.
And may we constructively assume that all witnesses have been sequestered?
Yes, they have.
And may we constructively assume that all witnesses have been pre-sworn?
Yes.
Your Honor, the plaintiff is ready to proceed at this time.
Okay. Defense?
Your Honor, the defense does have a few pretrial matters.
All righty.
We ask that the court take judicial notice of the 14 stipulations found on page 12 of our case materials.
All right.
Our case materials state that all documents have been pre-marked. We ask that to clarify that the exhibits have been pre-marked for identification purposes only,
That's correct.
and that we reserve our right to object as to the contents of these documents.
Fair.
Furthermore, Your Honor, we would like to clarify that the motion for sequestration does not apply to the two experts in this case,
As always, experts can remain in the courtroom.
and we would like to approach to present our team roster.
Okay? Yes, you may.
Your Honor, at this time, the defense is ready to proceed.
All righty. Plaintiff wish to give an opening statement.
Yes, Your Honor.
You may proceed.
May it please the court? Counsel. Members of the jury, do not worry. I take full responsibility for these scouts, and nothing will happen to them on my watch. These were the words spoken by this defendant before leading 3 scouts on an overnight camping trip that ended one of their lives. My name is Reese Opal, and I, along with my co-counsel, Victoria Benson and Abby Branham, represent the plaintiff in this case, Frances Mallory, who represents her deceased daughter, Sammy Mallory. Now, Ms. Mallory has been the single mother to her two daughters, Sammy and Hannah, ever since her husband was killed while serving in Afghanistan 8 years ago. Tragically, these girls were forced to grow up without their father, and now Hannah will be forced to grow up without her sister, Sammy. Now, when Mr. Mallory died 8 years ago, Mrs. Mallory did not want Sammy to fall behind socially or to have trouble coping with his death. So she enrolled her in a program known as the Wilderness Scouts, which is kind of a co-ed version of the Boy Scouts or the Girl Scouts. Now, their local branch of the Scouts, Troop 55, quickly became more than an outdoor learning experience for Sammy. It became like a second home. Sammy had been a member of that family at Troop 55 for a number of years when this defendant took over as Scoutmaster, the person in charge of leading the troop and supervising the scouts in all their activities. Now, the Wilderness Scout motto, "A scout is always prepared," means to the parents, the Scoutmaster must always be prepared as well. But she was not. Instead, you will learn that this Scoutmaster organized a camping trip that was strictly against the rules of the Wilderness Scouts. The parents had trusted this defendant. My client had trusted this defendant. They assumed she would follow the rules, but she did not. You will also learn that this defendant did not take along any other parents to help her supervise the scouts on this camping trip. In fact, no parents were even permitted to attend. Finally, you will learn that on this camping trip, this Scoutmaster was so preoccupied with her cell phone that she completely ignored the scouts. She did not at all see what they were doing or what hazards they were picking up. So it's really no surprise that around 9:45 p.m. on July 5th, 2016, a fire broke out in the cabin in which the three scouts were sleeping. This fire eventually burned Sammy Mallory to death. Now you will learn that this defendant was forewarned that that same scout, Blaze Thompson, had a dangerous fascination with fire and needs to be given special attention on this trip due to that obsession with fire, an obsession that turned deadly for Sammy Mallory. Now, investigator Sloan will take this stand and he will explain to you all of the evidence. He'll explain to you where this fire began and how it began. Inside the cabin. And it was caused by several items inside the cabin, including a grill, matches, and lighter fluid. This fire was not caused by electrical malfunctions. It was not caused by a lightning strike, and it was not caused by a firework accident. Simply by a scout with a dangerous fascination with fire. And the grill, matches, and lighter fluid that this defendant failed to notice. So you may wonder, why isn't that scout, the one that actually began the fire, on trial today instead of this defendant? Because members of the jury, it was this defendant who was tasked with being prepared. It was this defendant who was supposed to supervise the scouts. And it was this defendant who failed or breached that duty to properly supervise the scouts, to follow the rules about having no overnight camping trips, to notice and remove the obvious fire hazards, and to put into effect safeguards for the one scout who she was clearly warned needed extra adult attention. Now, at the end of this trial, Judge Jewett will explain to you that because we're the plaintiff in this case, we have what is called the burden of proof. That simply means it is our job to prove to you by a greater weight of the evidence that Scoutmaster Smith was negligent in this case. This means that Sammy Mallory would more likely still be alive today without the negligence of this defendant. And now we know that you're finding this defendant liable will not bring back Sammy Mallory. And it will not end the pain that Miss Mallory has to experience every day. But it will hold this defendant liable and responsible for her negligent supervision of the scouts in her custody on July 5th. And that is what we will ask you to do at the end of this trial, to find this defendant liable and responsible for her negligence. Thank you.
Thank you, counsel. Defense, you wish to give an opening statement?
Yes, Your Honor. However, before I proceed, if the rules had permitted me to object during opposing counsel's opening statement, I would have objected to the statements that the camping trip was against the Wilderness Scout rules, that parents were not permitted to attend the trip, and that Taylor Smith was warned of a scout's fascination for fire, all as argumentative.
All right, so noted.
May I proceed?
You may.
The plaintiff has just told you a tragic story. Sammy Mallory lost her life in a terrible accident. We cannot even begin to imagine the pain that Sammy Mallory's mother, Frances Mallory, must be experiencing. Now, it is easy to be overwhelmed by the sympathy in this case, and we get it. But it is also important to remember that sympathy does not equate to liability. It takes more. It takes proof. Proof by a preponderance of the evidence. A burden that the plaintiff cannot and will not be able to meet. And why? Because while the plaintiff may be able to control the sympathy, they cannot control the evidence. And the evidence simply does not support the plaintiff's case. Your Honor, members of the jury, good afternoon. My name is Angela Fajardo, and I, along with my co-counsel, Mr. Fernando Izquierdo, and Mr. Sebastian Aviles, represent the defendant, Taylor Smith. Taylor Smith. All she ever wanted to do was share her knowledge with the youth of the community. So she became a scoutmaster for the Wilderness Scouts. The parents of her troop urged Taylor to plan a camping trip to Camp Kindle for the Scouts. On July 5, 2016, while on this trip, the cabin where the Scouts were sleeping unexpectedly caught fire. Taylor was able to save 2 Scouts from that fire, and the evidence will show she did everything she could to try to save Sammy Mallory. Despite her best efforts, Sammy passed away. Now, as a defense, we do not have the burden of proof. Although we don't have the burden of proof, we will show that Taylor Smith is not liable. In this case, there are 2 experts, the teacher and the student. The plaintiff has brought you the student, but our expert, Chief Bailey Burns, taught the plaintiff's expert. Chief Burns will testify that the fire on July 5, 2016 started not inside, but outside of the cabin. You will learn that the fire was caused by factors beyond Taylor Smith's control. Blaze Thompson, a Wilderness Scout who actually went on the camping trip to Camp Kindle, will explain that Taylor was attentive to the Scouts throughout the trip. In fact, the only reason Blaze is able to testify today is because Taylor Smith saved her life. Finally, Taylor Smith herself will sit on that stand and explain that despite the multiple precautions she took to ensure the Scouts' safety on the trip to Camp Kindle, unforeseen events caused the Scouts' cabin to catch fire. Although she risked her own life and saved 2 other Scouts, her best efforts could not save Sammy Mallory. Today, the plaintiff is going to do everything they can to blame Taylor Smith for this unfortunate accident. And it is natural to try to place the blame by eliciting your sympathy. This is not about sympathy. It's about the law. Once you hear all of the evidence, we are confident you will find, while plaintiff may be able to control the sympathy, they cannot control the evidence. And the evidence simply does not support the plaintiff's case. And find Taylor Smith not liable for the wrongful death of Sammy Mallory. Thank you.
Thank you, counsel. Plaintiff, first witness, please.
Plaintiff calls Francis Mallory to the stand.
Ms. Mallory, come forward. You have been previously sworn. Take a seat in the chair and pull the microphone close, if you would.
Good afternoon.
Good afternoon.
Please turn and introduce yourself to the members of the jury.
My name is Frances Mallory, mother of the deceased Sammy Mallory.
And where do you currently live?
Currently, I live in Everglades, Florida, and I've done so my whole entire life.
Could you please tell us a little bit about your family background?
Yes, straight out of high school, I married my high school sweetheart. His name was Mark, and he enlisted in the Marines, but unfortunately, he was killed in the line of duty. So ever since then, I've been a single mother to Sammy and my younger daughter, Hannah.
Thank you, Ms. Mallory. Are you familiar with an organization known as the Wilderness Scouts?
Yes, ma'am.
And how are you familiar with this organization?
That was the organization that I enrolled Sammy in, and that was the organization that my husband was a part of when he was younger.
And to your knowledge, what is the purpose of Wilderness Scouts?
As we know, children are so involved in technology, and the Wilderness Scouts was designed to have children involved in the outdoors, in events such as hiking, fishing, learning about flora and fauna, that type of stuff.
Now, is this something that you and your daughter did together, or is it something that Sammy did alone?
She would do it alone, but I would attend meetings with her.
And to your knowledge, what troop were you and your daughter involved with?
She was a part of Troop 55.
And who was the Scoutmaster or the leader of Troop 55 in July of 2016?
Scoutmaster Taylor Smith.
Thank you, Miss Mallory. I'd like to talk to you about the reason we're in court today. I'd like to talk to you about July 5th and the events that transpired on that day. What was your understanding of what was to take place on July 5th?
Well, July 5th was just 4 days after Sammy's birthday. She had just turned 15, and the Scoutmaster had organized a camping trip, and Sammy and her best friend and another scout were to have an overnight camping trip on the July 4th weekend.
Were you originally concerned about this trip?
Yes, ma'am.
Did you approach the defendant with your concerns?
Yes, ma'am. I approached her. And she spoke to me words that I'll never forget. She told me, "Do not worry. I take full responsibility for these children, and nothing will happen on my watch." And clearly that's not what happened.
Miss Mallory, what day, to your knowledge, did your daughter leave for this camping trip?
July 5th.
And to your knowledge, did you have any interactions with this defendant or the Wilderness Scouts after July 5th?
Yes, ma'am.
In what capacity?
After I received that phone call, words cannot describe the grief and the pain that I felt. I continued to attend the Wilderness Scouts meeting to just feel some connection with Sammy, so yes, I did have interactions.
And did you learn anything from these meetings that you attended?
Yes, ma'am.
What did you learn?
I learned that the parents of Blaze Thompson had warned her.
Objection, Your Honor. Hearsay as to what Blaze Thompson's parents warned.
Response?
Your Honor, it is not hearsay because it is not being offered for the truth of the matter asserted, rather to show that this defendant was put on notice of the hazard that Blaze Thompson could be on this camping trip.
Your Honor, if I may, if they're trying to show that Taylor Smith was notified of Blaze Thompson's predispositions, then by showing that Blaze's parents told Taylor Smith about the predispositions, they would be offering that statement for the truth of the matter asserted.
That's right.
Your Honor, we are not attempting to prove that Blaze Thompson started the fire or that he is in any way at fault for the events that transpired on July 5th, rather that this defendant was negligent by not taking precautions based on the email he received.
Your Honor, if I may.
I'm going to allow overrule.
What did you learn at these meetings?
As I was saying, I learned that the parents of Blaze Thompson had warned the Scoutmaster of the previous incident that Blaze had with fire.
Your Honor, at this time, may I approach the witness with an exhibit?
Sure.
May the record reflect that I'm showing opposing counsel what has been previously marked as Exhibit 6 for identification. Ms. Mallory, could you please turn and tell the members of the jury what I just handed you?
This is the email that I learned about upon attending a meeting.
And is this in the same or substantially the same condition as when you last saw it?
Yes, ma'am.
At this time, Your Honor, may we move into evidence what has been previously marked as Exhibit 6 as Plaintiff Exhibit 6?
Objection, Your Honor. Hearsay.
Your Honor, I would defer to my previous argument on why this is not hearsay. It is being offered to show that this defendant was put on notice about the hazard that Blaze Thompson could be and failed to take safeguards prior to this trip.
Your Honor, if I may, just by entering this document does not show that the defendant was put on notice, as they have not established the predicate that the defendant ever received this document.
Yeah, I tend to agree with the defense counsel. I think that's the problem, is we don't know that the defendant ever saw this. So, sustained.
Yes, Your Honor. Ms. Mallory, how has your daughter's death affected you?
Every night at my dinner table, there's an empty seat. And every night, my younger daughter, Hannah, asks me when Sammy's coming home. And I just tell her that Sammy's visiting her father for a little bit. She doesn't quite understand the situation yet.
Thank you.
I will always be Sammy's parent.
Thank you, Ms. Mallory. I have nothing further at this time, Your Honor.
Cross.
Your Honor, before I proceed, permission to retrieve Exhibit 6 from the witness. Mallory, I understand that this whole situation must be difficult for you, so I'm just going to ask you a few questions, and I'll try to get through this as quickly as possible.
Yes, sir.
I just want to clarify up front, you did not attend the trip to Camp Kindle on July 5th, 2016, correct?
No, sir. I have a younger daughter at home, and I wasn't able to hire a babysitter, so I was not able to attend. No, sir.
We'll talk about that later, but I want to talk to you first about the parent monthly meetings that you would attend for the Wilderness Scouts. It's my understanding that Sammy's first Scoutmaster, Scoutmaster Margaret, would plan these parent monthly meetings on behalf of the Wilderness Scouts, correct?
Yes, sir.
When Scoutmaster Smith took over, she began planning these parent monthly meetings on behalf of the Wilderness Scouts, correct?
Yes, sir.
It was also the responsibility of the Scoutmaster to plan different activities and trips on behalf of the Wilderness Scouts, correct?
Yes, sir.
Scoutmaster Margaret would plan different activities like movie nights, beach cleanups on behalf of the Wilderness Scouts, correct?
Yes, sir.
Taylor Smith specifically planned the trip to Camp Kindle on behalf of the Wilderness Scouts.
Yes, sir. We've never taken a camping trip before. That was the first one we've ever taken.
It's your understanding that Scoutmaster Smith was the only chaperone attending on behalf of the Wilderness Scouts, right?
Yes, sir.
We'll get back to that later as well. But when you first learned about the planning of the trip to Camp Kindle, you were, in your own words, shocked, correct?
Yes, sir. As I said, as long as we've been a part of the Wilderness Scouts, we've never taken camping trips. I was shocked and I approached her.
You approached Scoutmaster Smith about whether this was something the Wilderness Scouts allowed.
Yes, sir.
However, you would agree that Scoutmaster Smith never specifically told you whether this was something the Wilderness Scouts allowed or disallowed, correct?
Yes, sir. I assumed that if she was telling the parents about it, that she had gotten permission.
So, even though you approached Scoutmaster Smith with your concerns, and she didn't tell you whether it was allowed or disallowed, you didn't check the Wilderness Scout rules yourself to see whether it was allowed, correct?
No, sir. She presented me with waivers, so I assumed that it was allowed, sir.
I want to talk to you about the waiver. You signed a permission form and liability waiver in this case, correct?
Yes, sir.
You would recognize this document if I showed it to you today?
Yes, sir.
Your Honor, permission to approach the witness with what has been previously marked as Exhibit 3 for identification purposes?
Sure. No problem.
Your Honor, let the record reflect that I'm showing opposing counsel the document of the hand of the witness. Would you like a copy, Your Honor?
No, I have one, thank you.
Ms. Mallory, you recognize this document, correct?
Yes, sir.
This is a fair and accurate representation of the permission form and liability waiver that you signed in this case.
Yes, sir. I signed a waiver, not a death warrant.
I understand that, but you would agree that in the middle of the page, that is your signature above parent's signature, right?
Yes, sir.
Your Honor, at this time, ISO has been previously marked as Exhibit 3 for identification purposes. Now be moved into evidence as Exhibit 3.
No objections, Your Honor.
All right, that will be,
Your Honor, permission to publish this document to the jury?
certainly.
Ms. Mallory, I want to draw your attention to the third paragraph. You would agree it states, I hereby release Wilderness Scouts from any and all liability, claims, demands, causes of action, or possible causes of action whatsoever arising out of or related to any loss, damage, or injury that may be sustained by my child while participating in or traveling to and from this event. You would agree that is what it states, correct?
Yes, sir.
Your Honor, permission to retrieve the document from the witness?
Mhm.
As you previously stated, Taylor Smith was the one attending the trip to Camp Kindle and was chaperoning this trip on behalf of the Wilderness Scouts, correct?
Yes, sir.
I want to go back to the trip to Camp Kindle. You would agree that since you did not attend the trip to Camp Kindle on July 5th, 2016, you cannot testify from your personal observations as to the steps that Scoutmaster Smith took to protect the Scouts during the camping trip, correct?
Yes, if he had protected my daughter, she'd still be alive today.
You would also agree that since you did not attend the trip to Camp Kindle, you cannot testify from your personal observations as to how the fire started.
Yes, sir.
Isn't it also true that since you did not attend the trip to Camp Kindle on July 5th, 2016, that you cannot testify from your personal observations as to anything that occurred during the camping trip, correct?
Yes, sir.
Your Honor, no further questions.
Redirect.
Briefly, Your Honor. Miss Mallory, was Scoutmaster Taylor Smith the head of the Wilderness Scouts organization?
No, ma'am.
What was she for the Wilderness Scouts?
Just a scoutmaster.
Your Honor, may I approach the witness with an exhibit that has already been entered into evidence?
Sure.
Miss Mallory, could you please tell the members of the jury who that waiver releases liability to?
Objection, Your Honor, lack of personal knowledge. Opposing counsel is asking this witness to testify as to a legal opinion.
Response.
Your Honor, I do not believe it is a legal opinion, as not only did she sign this paper, it specifically states that it only disallows liability to the Wilderness Scouts, not any individual Scoutmaster or employee of the Wilderness Scouts.
Your Honor, if I may, the interpretation of the liability form and who it releases is a legal opinion, and this witness has not been qualified as an expert in.
Well, the questions that you asked on cross were, did you agree to release on this? So I'm going to allow the question overall.
Thank you, Your Honor. Who does that form release liability from, Miss Mallory?
Wilderness Scouts.
So not the defendant?
No, ma'am.
May I retrieve my exhibit,
Sure.
Your Honor? And I have nothing further at this time.
Thank you. You step down, ma'am. Thank you. Next witness, please.
Your Honor, the plaintiff calls Sloan Barnes.
Barnes, come forward.
Good afternoon, Mr. Barnes.
Good afternoon.
Please turn and introduce yourself to the jury.
Hello, my name is Sloan Barnes.
And what is your occupation?
I'm a fire investigator for Everglades Fire Analytics.
And what does that mean?
I investigate fires in Everglades County and specifically in Everglades National Forest.
And how long have you been a fire investigator?
Specifically for Everglades Fire Analytics, I have worked since March of 2001. But before this, I worked for around 20 years with a private investigative firm. And prior to this, I worked with the Federal Bureau of Investigation, where I worked intimately with serious arson crimes around the nation.
I'd like to draw your attention to the reason we're in court today, a fire that occurred on July 5th of 2016. How did you become involved with this fire?
Due to our contract with Everglades County, Everglades Fire Analytics we are contacted whenever there is a fire in Everglades National Forest. And I was assigned specifically to this case.
And what evidence did you receive when you signed on to this case?
I received all depositions and relevant case reports, along with pictures taken the night and the day after the fire by Everglades Fire Department.
What evidence did you yourself gather?
I went to the scene as I find it crucial to do so. To get a clear picture of what happened that night, I find it crucial to visit the scene and actually take in the evidence there and conduct my own tests, such as electrical tests and tests to determine the fire was caused by fireworks.
And when you arrived at the scene, could you please describe the structure that was the subject of your investigation?
The cabin at Camp Kindle was kind of your standard cabin. It was a CBS wall frame structure, which is a concrete block structure sandwiched between two pieces of plywood, and on the roof was a palm thatch.
Could you please tell the jury what a flame pattern is?
A flame pattern it's the fingerprint of a fire. It's what a fire leaves in its wake. A flame pattern is key to a fire investigator because it tells them exactly where the fire started, what happens after the fire begins, and often what causes the fire.
And did you notice any flame patterns within this cabinet?
Yes, inside the cabin at Camp Kindle, there was a very distinct V-shaped flame pattern along the north wall.
Could you please explain what a V-shaped flame pattern is?
A V-shaped flame pattern is a flame pattern that looks like this. And at the apex of the pattern is where the point of origin is. It acts as an arrow directly to the point of origin.
And what color would a V-shaped flame pattern be?
According to the newest science research, this flame pattern would have been, on the inside, a lighter color, often white or gray, and on the outside, a darker brown or black.
And were any pictures taken of this V-shaped flame pattern?
Yes, there were.
Would you recognize these pictures if I were to show them to you?
Of course.
Your Honor, may I approach the witness and exhibit?
Yes, you may.
And may the record reflect that I'm showing opposing counsel was previously been marked as exhibit A.
Thank you.
Could you please tell the jury what I just handed you?
These are the pictures taken by the Everglades Fire Department the night of and the day after the fire.
And are they the same, or substantially the same as when you reviewed them?
Oh, yes, they are.
Your Honor, at this time I'd like to enter into evidence Exhibit 8 as Exhibit 8.
Defense?
No objection, Your
All
Honor.
right, to be accepted as plaintiff's.
Do you see the flame pattern in those pictures?
Yes, I do.
Your Honor, at this time I ask that the witness be allowed to step down to show the jury the pictures.
Sure. And if counsel wishes to move around the courtroom so they can see what he's pointing to, by all means.
Yes, Your Honor.
And Your Honor, at this time I'd like to also publish the evidence to the jury.
Okay.
It's 2 pages. And could you please explain where in these pictures you see this V-shaped flame pattern?
The jury could turn their attention to timestamp 1049 on page 46. And look towards the top right-hand corner of the picture. You can see the distinct V-shaped flame pattern along here. See going down with the lighter inside and the darker outside of the flame pattern.
Now, would this V pattern be clearer in person or in this photograph?
This V-shaped flame pattern would have been significantly more apparent in person, as going to the scene.
Objection, Your Honor, unfair extrapolation. This witness cannot testify as to the quality of the photographs and how clear the photographs are. It would be a lack of personal knowledge on his end.
Your Honor, if the witness was both at the scene and looking at these pictures, it is reasonable to assume that he is aware of whether the pattern was clearer in person or in this picture.
Yes, Your Honor. This witness did in fact visit the scene and was able to see the V-shaped pattern at the scene of the fire. However, there is no testimony in his affidavit as to whether or not the V-shaped pattern would have been clearer in person or in the photographs.
Well, I think the fact that he was there, he should be able to at least testify to a little of that, and I'll allow you, obviously, you can chase that around a little and cross. Proceed.
Now, was this V-shaped pattern clearer in person or would it be clearer in this picture?
Due to the nature of photographs, the flame pattern was definitely more evident, as anyone can attest to who has been to the scene of the fire. It was more evident actually at the scene than it is in this slightly blurry picture.
And what does this V pattern tell you?
This V pattern tells me that this fire started along the north end of the cabin, near what would have been this bed.
Thank you. Your Honor, I have to ask that the witness be allowed to retake the stand.
Back up.
Permission to return to my seat, Your Honor?
Sure.
Mr. Barnes, were you able to rule out any other causes of fire?
Yes, I was able to rule out electrical and the cause of fireworks starting this fire.
And how were you able to rule out electrical fires?
The electrical outlets inside of the cabin at Camp Kindle were GFI circuits. And when a GFI circuit is overloaded, it causes a fuse to short. And this is easy to determine because if you go to the fuse box and look to see if the fuse is shorted, it is evident because there's a switch flip, which there was not in this case.
And how were you able to rule out fireworks as a potential cause of fire?
Going into the investigation, I thought there was a possibility it could have been fireworks due to its proximity to the 4th of July weekend. However, after extensive chemical and physical testing, there was no evidence to make it apparent that fireworks caused this fire.
Now, could you please explain how quickly this fire burned?
This fire burned extraordinarily quickly. It went to completion in 5 to 10 minutes.
And why did this fire burn so quickly?
It burned this quickly because there was an accelerant in the cabin.
And could you explain what you mean by that?
Inside of the cabin, there was a Camp-Bright fuel. And the appearance of this Camp-Bright fuel would have caused the cabin to have an accelerant in it. This is because the vapor pressure of Camp-Bright fuel is higher than that of the normal atmosphere inside of the cabin, allowing it to evaporate into the air and saturate the air around it. This is why you cannot smoke a cigarette while you pump gas.
Now, based on all of the evidence that you received and analyzed and gathered and your expertise, what is your ultimate conclusion in this case?
Based on the depositions and the evidence that I personally collected, it is my conclusion that this fire started inside of the cabin along the north wall, and it was caused by a match or a fire pertaining to a grill that got out of control.
And was this fire intentionally or unintentionally set?
The fire inside of the cabin was intentionally set.
Objection, Your Honor. Improper opinion as to the intent of the fire.
Response?
Your Honor, I intend to clarify with my next question, but I believe this is within their expertise.
Okay, if you could clarify, we'll, just a second.
Yes, Your Honor.
You can clarify what you mean by intention.
Yes, Your Honor. Could you please explain what you mean by an intentionally set fire?
By intentionally set, I do not mean this fire was set with malicious intent. However, I mean that someone inside of the cabin meant to start a fire. I do not believe that they meant to burn down this cabin, but I mean that they meant to strike a match. Whether this fire propagated accidentally is another case, but this fire inside of the cabin was intentionally set.
Thank you, Mr. Barnes. I have nothing further this time, Your Honor.
And as to the objection, I overrule the objection based upon that explanation.
Yes, Your Honor.
Cross?
Yes, Your Honor. May I proceed?
You may.
Good afternoon, Investigator Barnes.
Good afternoon.
I'm just going to ask you a few questions that
Yes, sir.
I'm a bit confused about, and I ask that you answer within a reasonable degree of scientific certainty. For some reason, you can't just let me know and I'll rephrase my question, okay?
Okay.
During your evaluation of the cabin, during your direct examination, you previously testified that you're employed by the EFA.
Yes, I am.
You're getting paid for your testimony.
Yes, I am.
Specifically, you're getting paid by Everglades County.
Yes.
That's because, if my understanding is correct, Everglades County has been in contract with the EFA since about March of 2001.
Yes, I have.
As per that contract, you investigate all fires that occur within Everglades Forest.
Yes, me and EFA.
This contract was established in about March of 2001,
Yes.
making Everglades County a client of the EFA for about 17 years.
Yes.
And just to be clear, Camp Kindle was located within Everglades County.
Yes, it was.
You certainly wouldn't want to have an opinion that would be contrary to the interests of such a long-time client, right?
My opinion is purely my own. I'm not tampered with at all by Everglades County.
All right, Investigator Barnes, now I'd like to talk to you about what you did during your investigation. You previously testified that you reviewed photographs taken of the scene of the fire, right?
Yes.
Your Honor, permission to approach the witness with what has already been entered into evidence as Composite Exhibit 8.
All right.
This document has already been published.
Thank you.
Now, Investigator Barnes, you previously testified that you believe that the hypothesis that fireworks landed on the roof of the cabin, thus causing the fire, would be unlikely.
Yes, it would be implausible.
That's because fireworks landing on the roof of the cabin would have left distinctive gunpowder residue on the roofing material of the cabin.
on the roofing material or after the roofing material burned down on the floor of the cabin.
I'd like to direct your attention to page 45, the middle photograph, timestamp 2216. You would agree that there is no roofing material left remaining on the cabin.
No, just cinder blocks.
Moving on to page 46, the top photograph showing the aerial view of the cabin remains.
Yes.
There's also no roofing material left on the cabin.
No, just cinder blocks.
So it'd be fair to say that in all the photographs in court today, there is no roofing material remaining in cabin 1.
There is not.
Yet despite the total lack of roofing material evidence, you were able to rule out the hypothesis that fireworks landed on the roof of the cabin?
Yes, because in my chemical test, I would have been able to determine if there would have been gunpowder or saltpeter, as it would have then fallen to the ground.
Oh, okay, so it's your testimony that the roofing material was on the ground of the cabin?
After
The
it
substance
burned.
that you tested?
After it burned, yes, it would have fallen down into the ground of the cabin.
This is the same material that's covered in dirt in the top photograph, right?
Ash and dirt.
And debris.
Yes.
It's also being, what it looks like, trampled on by 12 firefighters.
Yes, I see firefighters in the picture.
And this was the material that you tested.
This is the material that I tested.
I'd like to direct your attention to another portion of your opinion. You believe that the fire started within the cabin, right?
Yes.
This is as a result of a V-shaped pattern on the northern end.
Yes.
This was a very distinct V-shaped pattern, was it not?
Yes, it was.
And this distinct V-shaped pattern indicated to you that the fire started inside the cabin.
Yes, it did.
Since this piece of evidence substantiated your opinion, it would be very important to document, right?
Yes.
Can you please point out to the jury where the V-shaped pattern is located within any of the photographs?
As I previously stated, in timestamp 1049 on page 46, you can see the V-shaped pattern identified by the lighter coloring followed by the darker outside coloring that points to the ground alongside the north wall.
Just to be clear, it's your testimony that the very distinct V-shaped burn pattern is the white blur on the corner of the middle photograph on page 46?
While it may be difficult for the untrained eye to see, someone with as much experience as I can definitively tell you that, yes, this is the V-shaped pattern.
You're aware that this jury has the document in their hands?
Yes, I am.
Investigator Barnes. No further questions, Your Honor.
You redirect.
No, Your Honor.
Thank you, sir. Step down. Next witness, please.
The plaintiff calls Adrian Sutler to the stand.
Mr. Sutler, come forward.
Please turn and introduce yourself to the members of the jury.
Good afternoon. My name is Adrian Sutler.
And Mr. Sutler, how old are you?
I'm currently 19 years old.
Now, at the time of this fire at Camp Kindle, how old were you?
I was 17.
Mr. Sutler, what is your relationship to Sammy Mallory?
Sammy was my best friend. We did everything together. From soccer to lacrosse, even student government. We were the best friends.
Are you familiar with an organization known as the Wilderness Scouts?
Yes, and I'd been a member for about 6 years. Sammy was the one that got me to join.
And could you briefly describe exactly what the Wilderness Scouts is?
The Wilderness Scouts is a youth organization which is kind of like a co-ed version of the Boy Scouts, but with more of an emphasis on wildlife, nature, and learning, but with more of a classroom-style tutorial and this one camping trip.
Now, within this organization, are there different levels of scouts?
Yes, there are.
And what level scout are you, Mr. Sutler?
I was a khaki scout.
Are you aware of the attributes that the parents and the scoutmaster are looking for when nominating someone for this position?
Yes. Khaki Scout is given only to those who demonstrate the best qualities of the Wilderness Code, as well as a unanimous vote cast by the Scoutmaster and the parents of the troop that you are hardworking and honest.
So you'd agree with me you have to be familiar with the Wilderness Code in order to be a khaki scout?
Yes, that's correct.
Your Honor, may I approach the witness with an exhibit?
Sure.
May the record reflect time showing that the counsel was previously marked exhibit 1.
Mr. Sutler, do you recognize this?
Yes, I do.
And what is this?
This is the outdoor adventure policy, which is a portion of the Wilderness Code.
And how do you recognize
As a khaki scout, I'm required to know it like the back of my hand.
it? Is it a fair and accurate copy of the wilderness policy the first time you saw it?
Yes, it is.
Your Honor, at this time, I'd like to enter into evidence Exhibit 1 as Plaintiff's 1.
Your Honor, we would object as to hearsay.
Your Honor, may I respond?
Sure.
Your Honor, this is an exception to hearsay because it is a regularly kept business record. Pursuant to page 73 of our case packet, Rule 5, because we have a certain case in chief, we are not able to bring in the business custodian, but we are able to enter this as into the next qualified witness.
Response as to that?
Your Honor, opposing counsel has not laid the proper predicate to enter this document under the records of regularly conducted business activity hearsay section. They have not established that was made at or near the time by from a person who has knowledge, nor have they established that this person would be a custodian or would be able to handle this document within the business.
Response.
May I respond?
Sure.
As a khaki scout, this witness would surely have to know about the Wilderness Code as he has testified in the Wilderness Policy, so he would know of this exhibit.
I'll allow it. So accepted as plaintiff's 3, I believe.
So, Mr. Sutler, what troop were you a part of?
I was a part of Troop 55,
Who was the scoutmaster of that troop?
Scoutmaster Taylor Smith.
For how long was she your scoutmaster?
She was Scoutmaster since about 2015.
Now, turning your attention to the camping trip that took place at Camp Kendall, did you want to go?
At the time I did. I thought it would be a great time to hang out with my best friend Sammy.
And who all was offered to go on this camping trip with?
Only the other scouts in the troop.
And who actually ended up attending?
Only 3 of us. That's how I should have known the trip wasn't going to go well.
Now, who drove all of you to the campsite at Camp Kendall?
Scoutmaster Smith drove us.
And where did you store your luggage on your journey to the campsite?
In her vehicle.
Now, once you arrived at the campsite, what did you all begin to do?
Scoutmaster Smith, from the second we got there, was on her phone checking emails or texts. Blaze Thompson, the other one of the scouts that went along with Sammy and I, she was constructing firewood and rocks to create a fire pit, and that left Sammy and I alone to unpack all the luggage.
Did Scoutmaster Smith ever say that she was going to conduct a perimeter check?
No.
And although you never heard her say that she would conduct one, did you ever actually see her conduct one?
No, ma'am.
So going back to this Blaze Thompson, you said she was constructing a fire-like structure, correct?
Yes, that's correct.
Objection, Your Honor. Meeting.
Your Honor, I can rephrase.
All right.
Could you please repeat what Blaze Thompson was doing when you arrived?
She was constructing a fire pit.
Did Scoutmaster Smith ever stop her from constructing this fire?
No, in fact, after Blaze had gone out and asked if we could have s'mores, Scoutmaster Smith took over and built the fire for us.
So after this fire, what happened next?
After that, Scoutmaster Smith told us to go to bed.
Well, now, when you got in the cabin, was there any items that concerned you?
Over near the north wall of the cabin, next to Blaze's bunk, there were these odd canisters tucked away, but I never really got a good enough look to see exactly what they were.
Were there any items in your other scouts' possessions that concerned you?
Blaze Thompson had this box of matches that she'd found on the campsite. She would light one on a book flap and then let the air conditioner unit blow it out. I told her to put them away since we shouldn't have had them at the campsite. She did, and I thought the situation was handled.
Could you please explain to the members of the jury the layout of this cabin in which all you scouts slept?
Yes. In the cabin, there were 2 bunk beds. Sammy and I had one, and then Blaze had his. It was near the north wall of the cabin next to the window. That's where the canisters were.
Now, after you went to bed, what happened next, Mr. Sutler?
I heard this loud explosion, almost as if a gunshot had gone off right next to my head. And that's what woke me up. And there were flames rushing towards me. Smoke was filling my lungs. I was so scared I couldn't even scream.
Now, when you were safe outside of that fire, were you made aware of any news?
My best friend had died.
Nothing further, Your Honor.
Cross.
Yes, Your Honor. However, before I proceed, I request you retrieve opposing counsel's
Sure.
exhibit. Good afternoon, Mr. Sutler. I'm just going to ask you a few questions to help clarify your direct examination.
Yes, ma'am.
It's my understanding that you're a khaki scout.
Yes, that's correct.
This is the highest honor that you can earn in the Wilderness Scouts.
Yes, Sammy and I were inducted on the same night.
To be a khaki scout, you have to demonstrate the best qualities of the Wilderness Code.
As well as hardworking and honest.
This Wilderness Code includes responsibility.
Yes, it does.
It also includes honesty.
Yes.
It would be fair to say that as a khaki scout, you would make the right people aware of any dangerous situation that you may witness, right?
Yes, I would.
Now, you mentioned on direct examination that while you were on the camping trip to Camp Kindle, you saw that Blaze Thompson had matches.
Yes, that's correct.
Blaze actually lit some of these matches inside the cabin.
Yes, and then he would let the air conditioner unit blow it out. I told him to put them away. He did, and I thought that was the end of that.
However, you know that matches can be dangerous, correct?
Yes.
You also knew that you were not supposed to have matches at the campsite.
Yes, we weren't adults. I didn't think we should have them.
So even though you knew that matches can be dangerous and that they weren't allowed, you never told Scoutmaster Smith that Blaze was in possession of matches, did you?
No, I didn't.
And then you went outside to have a small campfire with the scouts, right?
Yes, we did. We had s'mores.
Scoutmaster Smith was there, correct?
Yes, he was.
However, you never told Scoutmaster Smith then that you saw that Blaze had matches.
I'd assumed Blaze had given him the matches to start the fire for the s'mores.
However, the last you saw of the matches was that Blaze had them in her pocket.
Yes, she'd left the cabin to go talk to Scoutmaster Smith with them in her pocket.
And you never told Scoutmaster Smith that you saw her with them at all.
No, I didn't.
So to be clear, you were neither honest nor responsible in reporting the matches that you saw to Scoutmaster Smith.
I didn't tell Scoutmaster Smith. I thought I could trust Blaze.
Okay.
Did she start the fire?
I'd appreciate if you just answer the questions that I ask you. Is that okay?
Yes, ma'am.
All right. Now I'd also like to discuss some preparations that were made for the camping trip. You knew that Taylor Smith prepared certain documents before the camping trip.
Yes, he did.
You know that Scoutmaster Smith prepared food menus.
Yes.
You know that she prepared allergy lists,
Yes.
maps of the campsite,
Yes.
even itineraries.
Yes.
Now I'd like to discuss the fire that occurred while you were at Camp Kindle. You would agree that you were asleep when this fire started.
Yes, and the loud explosion as if it was a gunshot or like lightning had just struck our cabin woke me up.
All right, we'll discuss the sound in a moment, but you woke up to the sound, so it would be fair to say that you cannot testify from your personal observations as to how the fire started because you were asleep.
That's correct.
And when you woke up to the sound of the fire, in your own words, you previously testified that it sounded like a firecracker, correct?
I said that when I gave my deposition that it was like a loud noise like a firecracker, yes, but I never said that here today.
Right, but you did previously describe the sound as a firecracker.
Yes, as well as a gunshot or like lightning had just struck in our cabin. That's
Exactly.
correct.
Like lightning had struck your cabin. You understand that lightning comes from outside, right?
Yes.
Then after you heard the sound of lightning striking your cabin and firecrackers, you heard voices outside the cabin.
Yes.
Objection, Your Honor, hearsay.
Your Honor, no specific statement has been made at this point.
Response?
Your Honor, I believe that the statement that opposing counsel is going to offer is hearsay.
Okay, well, let's get there first. As to this one, overrule.
Yes, Your Honor.
You heard voices outside the cabin,
Yes, I did.
and you heard those voices say, those nerdy scouts, I knew we'd find them here.
Objection, Your Honor, hearsay.
Response.
Your Honor, we are not offering this statement to prove the truth of the matter asserted, that the scouts were nerdy or that the declarant knew where to find the scouts. Rather, we are offering the statement to show that the voices were in close enough proximity to the witness that they were able to clearly distinguish what the voices were saying.
That's not what the question was, though. So I'll sustain the objection. You can rephrase.
Yes, Your Honor. You were able to distinguish exactly what the voices were saying from outside your cabin, correct?
Yes, I heard what they said. At least, what I think they said.
And then, after you heard these voices, you lost consciousness.
Yes.
And when you woke up, you were outside of the cabin.
Yes.
Scoutmaster Smith was standing over you when you woke up.
Yes.
Mr. Sutler, isn't it true that you're alive today because Scoutmaster Smith saved your life?
All I know is I woke up outside.
And Scoutmaster Smith was the one standing over you, right?
Yes, he was standing over me.
And no one else was there besides Scoutmaster Smith and the Scouts?
At that point, yes.
Thank you. Your Honor, no further questions.
Redirect.
Briefly, Your Honor. May I publish to the jury what has been entered into evidence as Exhibit 1?
Sure.
I have nothing further at this time, Your Honor.
All right. Thank you, sir. Any additional witnesses for the plaintiff?
No, Your Honor. At this time, the plaintiff rests.
First witness for the defense, please.
Yes, Your Honor. At this time, the defense calls Bailey Burns to the stand. May I proceed?
You may.
Good afternoon.
Good afternoon.
Please state your name and occupation for the court.
Bailey Burns. I'm a private fire investigator for my own legal consulting business.
What experience do you have within the field of fire investigations?
I was a firefighter for over 20 years before working my way up to fire chief. I retired 3 years ago.
What is your educational background?
I received my bachelor's degree in mechanical engineering from Everglades University, my master's in forensic studies, and my doctorate in fire engineering. I'm also a published author.
What kind of publications have you authored?
I have written 3 textbooks pertaining to fire point of origin and cause that are currently used in nationally recognized universities.
Based upon your previous publications, as well as your experience, have you ever testified in court as an expert witness?
Yes, I've testified in over 80 cases, 50 of which pertaining to fire point of origin testing.
Your Honor, on page 12 of our case materials, stipulation number 10, it states that Chief Bailey Burns has already been stipulated to as an expert witness. Therefore, we ask that the court recognize the stipulation and allow Chief Burns to give her expert opinion within the field of fire investigation and fire origin.
She will be recognized as an expert in her field of expertise.
Chief Burns, how did you become involved in this case?
I was contacted by the defendant's representatives in March of 2017 regarding a fire that took place on July 5th of 2016.
Just so that it's clear with the members of the jury, are you receiving any compensation for your evaluation?
Yes, I received the competitive rate for someone with my level of knowledge and expertise, which is $450 an hour.
Based on your evaluation, were you able to arrive at an opinion as to where the fire originated in Camp Kindle on July 5th of 2016?
I was.
Now, before we discuss your opinion regarding the fire, I'd like to talk to you about how you arrived at that opinion. What did you do during your evaluation?
During my evaluation, I reviewed 153 photographs of the scene of the fire to gain a better understanding of how the fire actually occurred.
Would you recognize some of these photographs if I showed them to you today?
I would.
Your Honor, permission to approach the witness with what has already been entered into evidence as Composite Exhibit 8.
All right.
Chief Burns, how did these photographs assist your evaluation?
These photographs are documentation of the fire during and immediately after the fire. Because I began my evaluation in April of 2017, these photographs provided me with the most accurate information I could have received.
Well, maybe you can help me with something, Chief Burns. The plaintiff's expert, Investigator Barnes, testified that he actually visited the scene of the fire. Did you ever visit the scene of the fire?
No, and there's a good reason for that. Because I was retained almost a full year after the fire, the scene was already far too contaminated to extract any viable evidence. The only viable evidence would have to have been extracted immediately after the fire.
Speaking of the plaintiff's expert, are you familiar with Investigator Barnes?
Yes, Sloan was my student, and I was his teacher when he was receiving his associate's degree, which is why I'm a bit surprised at how he arrived at his opinion.
Why would Investigator Barnes' opinion surprise you?
There are actually two issues that I have with Sloan's opinion. The first is that Sloan seems to believe the fire was started through the use of an accelerant. And while I agree there was an accelerant inside the cabin, Sloan did not consider that there was another highly flammable fuel source in the dry palm leaf overlay that made the roof of the cabin.
You mentioned that you had two issues concerning Investigator Barnes' opinion. What is your second issue?
My second issue is that Sloan improperly identified a V-shaped burn pattern when he was trying to say that it was lighter on the inside and darker on the outside.
Why would Investigator Barnes be incorrect?
Well, when a fire starts next to a wall, the smoke from the fire would rise along the wall, depositing soot, or the byproduct of a fire, onto the surface of the wall, leaving a darker burn mark. The smoke would continue to rise until it reached a ceiling, at which point it would gather and spread sideways, creating the wider top and narrower base, resulting in that darker V-shaped burn pattern.
All right. Since you weren't able to identify a V-shaped pattern, how did you arrive at a point of origin?
In this case, I had to revise my methodology. I examined the burn patterns in the photographs. I was able to determine that they were fairly even, as you can see in this top photograph. Well, I can try to point and explain, but I think it might be easier for the jury if I can get up and actually show them what I'm gesturing to.
Your Honor, permission for the witness to step off the stand?
Sure. Step down. Opposed counsel, if you want to move around the courtroom so you get a better view.
Now, you were mentioning something about the burn patterns in the photographs.
Yes, the even burn patterns.
Okay, so why would even burn patterns be significant?
Well, because the roofing material, the dry palm leaf overlay, as seen in this bottom photograph on page 45, was completely destroyed, the only evidence was the burn patterns on the walls. Even burn patterns, as seen in this top photograph on page 46, indicates that the fire spread uniformly down all the walls of the cabin.
aside from the even burn patterns, was there any other evidence that led you to a point of origin?
Absolutely. In the bottom photograph on page 46, showing the interior of the cabin remains, all of these plastic items are burned solely on the top, indicating there was a heat source above the items. In fact, this heat source was intense enough to melt 2 of the plastic items in the background of this photograph.
Were these photographs the only photographs that you used to arrive at an opinion?
Actually, no. There was another piece of evidence. In the top photograph on page 45, time-stamped 2210, you can see all the smoke is coming out of only the tops of the windows. If the fire had started inside, like Sloan believes, there should be smoke coming out of the entirety of the window. However, that's just not the case in these photographs.
Your Honor, permission for the witness to return to the stand?
She may.
Chief Burns, you previously testified that you were able to arrive at an opinion as to the origin of the fire that occurred in Canton. After reviewing all the evidence that you just mentioned, what is that opinion?
It is my expert opinion that the fire started on the roof of the cabin at the dry palm leaf overlay and expanded uniformly down all the walls of the cabin, resulting in even burn patterns.
Is this opinion made within a reasonable degree of scientific certainty?
It absolutely is.
Thank you. Your Honor, no further questions.
Cross.
Yes, Your Honor. You would refer to yourself as an expert for hire?
I am an expert that can be hired, so yes.
And your company motto is, don't get burned by opinions you don't want to hear, correct?
Yes, it is.
So for a fee, you'll provide justice for you.
For a fee, I provide my expert opinion.
And to be clear, the defense is paying your fee today, correct?
Yes, they are.
And your fee is $30,000?
Yes, it is. Well, $450 an hour. In this case, that's what it turned out to be.
So let's talk about this investigation. There are 4 standard procedures to perform a point of origin examination, correct?
Yes, there are.
The first is a review of photographs.
Yes.
The second is a review of satellite imagery.
Yes.
The third is to visit the scene.
Yes.
And the fourth is to conduct chemical testing.
Again, right.
And you did not conduct any chemical tests, did you?
No, in this case, I didn't feel they were necessary. However, if I had, I could conduct any necessary tests from my state-of-the-art laboratory.
And you did not view any satellite imagery, correct?
No, satellite imagery is more used for acts of God, like wildfires, where there's a larger point of origin. In this case, satellite images wouldn't have been able to capture the minute details, like the burn patterns.
And you did not visit the scene, did you?
No, like I was saying earlier, the scene would have been too contaminated. Going to the scene actually would have led me to an inaccurate opinion.
So of the 4 standard procedures, you did 1?
Yes, in this case, only one was necessary.
Your $30,000 investigation, you looked at some pictures.
Yes, 153.
And these were some of the pictures that were available, correct?
No, I reviewed all the available pictures, the 153.
But you're not certain if other photographs might exist, correct?
Yes, I don't know if there are any more pictures. I wasn't provided any more pictures.
And according to your own words, no matter what these other pictures contained, they could not change your opinion.
No, they would not.
So, hypothetically, if these pictures were to contain someone striking a match, this could not change your opinion.
I don't think I agree with the premise of your question. There would be no picture of someone striking a match in the aftermath of a fire.
Right, but if there was this picture, that could not change your opinion, correct?
I don't believe that picture exists, no.
I'm not asking if you believe the picture to exist. I'm simply asking, I'm posing a hypothetical to test what you have just said. Now, if you saw someone striking a match in one of these pictures, that could not change your opinion.
Counsel, you're asking me to speculate on something that simply doesn't exist. I cannot testify as to any photographs I have not seen.
Of course. So, just to be clear, regardless of any evidence that could possibly exist, your opinion would not change.
No, I reviewed all the relevant evidence in this case.
Okay. And your certification from the Elite Fire Academy lapsed in July of 2015, correct?
Objection, Your Honor. Relevance.
Your Honor, I'm attempting to question the credibility of this witness.
Your Honor, if I may. On page 55 of our case materials, Rule 3, Section 3, it states that if a witness is stipulated to as an expert, their qualifications may not be challenged. Questioning Chief Burns on her lab certifications would be considered challenging her qualifications. Therefore, it would be irrelevant and improper to question Chief Burns on this.
Your Honor, while voir dire is not permitted in this setting, I'm not permitted at that point to question her credibility, so at this time, I'm questioning her credibility and not actually her qualifications.
All right, I'm going to allow it. I think obviously once a person's found to be an expert, there could be certain strata of experts, and there may be something about the person as an expert that would make them a less quality expert as the other. So I think this is fair. I'll allow the question. Overrule.
Yes, Your Honor. Now, your certification from the Elite Fire Academy lapsed in July of 2015. Yes or no?
Yes, it did. However, I hold numerous licenses in the field of fire investigations.
But specifically the one that I'm referring to lapsed before your investigation in this case began? Yes or no?
Yes, however, any certificates I have are simply extra. My licenses are what qualifies me to do my job.
Thank you. I have nothing further, Your Honor.
You direct?
Not necessary, Your Honor.
All right. Thank you, ma'am. Next witness, please.
The defense calls Blaze Thompson to the stand.
Go forward, ma'am.
May I proceed?
You may proceed.
Good afternoon.
Good afternoon.
Please state your name and age for the court.
Blaze Thompson, I'm 17.
Ms. Thompson, do you currently attend school?
Yes, I go to North Everglades High.
Are you involved in any extracurricular activities?
I am. I'm in the Wilderness Scouts, and I have been for about 3 years now.
What did you do in the Wilderness Scouts?
We did a lot of different activities in the Wilderness Scouts. I mostly joined because I wanted to learn about the environment and get involved with nature. I remember being really excited about going on my very first ever camping trip with my Wilderness Scouts troop to Camp Kendall.
Why were you excited to go on this trip?
Well, I've always had an interest in fire and pyrotechnics, and the fact that we were going to be able to see the fireworks festival from our campsite was actually one of the reasons that I went on the trip. It's always fascinated me the way a simple chemical reaction can produce a multitude of colors.
You mentioned that you went on the camping trip to see fireworks. Did you get the chance to see these fireworks during the trip?
Yes and no. We weren't able to see the fireworks from the festival since there was too much cloud coverage. And Scoutmaster Smith didn't allow us to go since it wasn't authorized on the permission form.
Then how did you see fireworks?
Well, we weren't able to see the fireworks from the festival,
But we did get to see some fireworks that some other people were shooting off. It wasn't much, but it was some consolation.
These other people you're referring to, how far away were they?
They were about 50 feet away, I would say. And they were loud. I mean, blasting music. And they had this enormous bonfire, which Scoutmaster Smith mentioned wasn't even set up properly. That was when I asked Scoutmaster Smith if she could show us how to properly construct a campfire.
Did Scoutmaster Smith show you how to properly construct a campfire?
Yes. Not only did she show us how to properly construct the campfire, but she also showed us how to properly put out the campfire.
After the campfire, did you and the other scouts participate in any other activities that night?
No, we were all getting pretty tired, so we decided to start heading into the cabins. Scoutmaster Smith walked around the cabins and then went inside of her own cabin.
Do you remember what time you went to sleep?
Well, I didn't go to sleep right away. I wasn't really tired yet, and I was actually getting kind of hungry. So I decided to use some matches that I'd found and the portable grill that I'd brought to cook some hot dogs.
You indicated that you brought a portable grill. Did you ever tell Scoutmaster Smith that you had a portable grill?
No, I didn't really think that it was necessary. I had it in my bag the entire time up until I took it out to make the hot dogs.
I need to get clarification on something. Did you ever inform Scoutmaster Smith that you had matches?
No. Why would I? It didn't really seem important.
At any point in time, did you ever request permission from Scoutmaster Smith to cook these hot dogs?
No. It was already getting dark outside, and I didn't want to go outside alone in the dark, so making the hot dogs inside just seemed more reasonable.
Okay. Were you able to cook these hot dogs?
Yes. And as I was cooking the hot dogs, I saw some fireworks from outside of the cabin window, and they were much closer than fireworks in the festival would have been. Then I started to smell something burning, and I turned around to see what it was, but everything happened so quickly, and I blacked out.
Were you able to see where the fire started?
No. I didn't see the fire start anywhere inside of the cabin. I just remember waking up on the outside after I had blacked out.
How did you get out of the burning cabin?
It's my understanding that Scoutmaster Smith actually pulled me out of the fire. Scoutmaster Smith had risked her life to save me and Adrian, and she had tried to save Sammy. I owe her my life.
Thank you. Your Honor, no further questions.
Cross?
Yes, Your Honor. Now, Ms. Thompson, as you stated earlier, you were one of the 3 scouts that attended that camping trip to Camp Kendall.
Yes, I was.
And Scoutmaster Smith was the only adult on this camping trip, right?
Yes, she was.
So she drove you to the campsite, right?
Yes, we all drove to the campsite on July 5th.
Now, Scoutmaster Smith never gave you a list of prohibited items, did she?
No, I don't really see why she would have. I mean, we all know not to bring silly things.
Right. Isn't it true you brought a grill?
Yes, I did. It's important for a scout to always be prepared for any type of situation.
And yes or no, you brought campfire fuel,
Yes, I did.
which is a lighter fluid, right?
It is. It is a lighter fluid, and I brought it because I wanted to make sure that I could keep my lantern lit. I knew we were going to be in a dark and secluded area. I just wanted to be prepared.
Right, so once you arrived at the campsite, you wanted to make a fire, didn't you, Miss Thompson?
Yeah, I really wanted to have the whole camping experience. So we tried to convince Scoutmaster Smith to let us have a small campfire so we could make some s'mores.
And Scoutmaster Smith did make that fire for you, didn't she?
Yes, she showed us how to properly construct it and everything.
Right, so after this fire, she sent you all to bed, right?
Yes, she told us to go inside of the cabins.
Now, at some point, Miss Thompson, you found matches on the ground, didn't you?
Yes, but I don't know if it was at that time. I just remember finding them on the ground somewhere. I'm not really sure if it was even at the campsite.
While you were in the care of Miss Smith, you found matches on the ground, didn't you, Miss Thompson?
Well, like I'm saying, I don't remember when I found the matches. It could have been any time, really. I just remember finding them on the ground.
So once you got in your cabin, Sammy and Adrian went to sleep, didn't they?
Yes, they did.
But as you stated earlier, you were hungry.
Yes, I was.
So you got out your grill, right?
Yes, I did.
And then you used campfire fuel as an accelerant for this grill.
Yes, I did use the campfire fuel to light the grill. You kind of need a fuel source.
Of course, Miss Thompson, but you did not use the campfire fuel that you had brought.
No, I didn't. I actually found a canister inside of the cabin, which was pretty convenient.
That's right, you found used canisters of lighter fluid inside of your cabin, right?
Yes, I did. They were kind of tucked in the corner near one of the beds, and so I used that rather than using my own.
So you'd use this accelerant, and then you used the matches that you found on the ground to light your grill, right?
Yes, I did have to light the grill to cook the hot dogs.
Now, after lighting this grill, you, as you said earlier, you saw fireworks, right?
Yes, there were these magnificent bursts of red, white, and blue, and they were so close to the cabin.
Yes, you saw these fireworks, and then you looked at your phone, correct, Miss Thompson?
Yes, I did.
So, yes or no, sequentially, you poured campfire fuel on your bed. You then lit a grill inside of the cabin, and then you looked at your phone. And after those three things happened, you felt a blast of heat that knocked you unconscious, yes or no, Miss Thompson?
Well, yes, but it wasn't quite like you're explaining it. I spilled a little bit of campfire fuel, and I was able to clean it up. I've done a lot of research, so I'm aware of the proper precautions to take. Then I lit the grill, and then I just started playing some music on my phone.
So, would the answer to my question be a yes? Sequentially, you poured campfire fuel on your mattress, you then lit your grill inside of the cabin, and then you looked at your phone, and that is when you felt the blast of heat. Yes or no?
Objection, Your Honor. This question is ambiguous and compound. It can be answered in multiple different ways. Since there are different aspects of opposing counsel's question, the witness tried earlier to answer yes to some and clarify that it was no to others. If opposing counsel can break up the question.
Your Honor, I'd be more than happy.
Okay.
Miss Thompson, yes or no, you spilled campfire fuel on your bed.
Yes, I did, but like I said, I was able to clean it up.
So yes, you did pour the campfire fuel. You spilled the campfire fuel on your bed.
Yes.
Yes or no, you then lit a match on your grill.
Yes, I did.
Inside of your cabin.
Yes, it was inside the cabin.
And yes or no, you then looked down at your phone.
Yes, I had to listen to some music, and I just used my phone to play some.
Miss Thompson, all I need is a yes or a no. It was after these three things happened that you felt the blast of heat. Yes or no? Will do.
Yes, and I'm not really sure where it came from. It was just this blast of heat.
Thank you, Your Honor. I have nothing further.
Redirect.
No redirect necessary, Your Honor.
Thank you, ma'am. Next witness, please.
Your Honor, at this time, the defense calls Taylor Smith to the stand.
Smith, come forward, please. You may proceed.
Good afternoon.
Good afternoon.
Please state your name for the jury.
Taylor Smith.
Ms. Smith, are you currently employed?
No, not anymore. However, I was previously the Scoutmaster of the Wilderness Scouts.
Why did you decide to become a Scoutmaster?
I love the environment, and ever since I was young, I knew I wanted to teach. Being a Scoutmaster just gave me the opportunity to do both.
What were some of your responsibilities as Scoutmaster?
I would teach the Scouts about Florida's fauna, prescribed burns, which are intentionally caused wildfires, and it would lead into lessons about respreading. I was especially excited about teaching invasive plant species, and I also planned different activities and trips to incorporate hands-on learning.
We've heard testimony about one trip in particular, the trip to Camp Kindle. Did you plan this trip?
Yes, I'd planned a similar trip with my previous troop, Troop 47. The parents had heard about the success of my trip and asked me to plan one for Troop 55. I was happy to.
Since the parents are the ones that asked you to plan this trip, did you discuss the details of the trip with the parents?
Yes. At one of the parent monthly meetings, I had informed the parents that the trip would be taking place on July 5th. I also had the parents sign permission forms before we could actually go on the trip.
Why did parents have to sign permission forms and liability waivers before you could go on the trip to Camp Kindle?
There are always risks involved in any sort of activity, especially a camping trip. I wanted the parents to be aware of these about these risks, as well as give permission for their child to attend the trip.
Did all of the parents sign this document?
No, only the parents that wanted their child to attend the trip would sign the permission form. Some of the Scouts actually opted out on the trip. The parents who signed the forms were Adrian Sutler's, Sammy Mallory's, and Blaze Thompson's.
Now, I want to fast forward to the events of the Camp Kindle trip. What was the first thing you did once you arrived at the campsite?
My first duty as Scoutmaster was to conduct a safety check of the perimeter to ensure the safety of the Scouts.
Can you clarify for the jury what you did in your perimeter check?
Well, just to be clear, in this trip, I conducted 2 perimeter checks, not just one. I conducted my first perimeter check when we arrived at the campsite. It consisted of checking the campsite itself, as well as the inside of the cabins, to ensure that they had a fire extinguisher as well as a hose.
Okay, so then what did you do in your second perimeter check?
I conducted my second perimeter check right before going to bed. It was to double check my findings from my first perimeter check. I didn't find anything dangerous in either of my perimeter checks.
You mentioned that you conducted your second perimeter check right before going to bed. Do you remember what specific time you went to sleep?
Yes, it was around 9:45, but I woke up a couple minutes later to some crackling sounds.
Crackling sounds?
Yeah, it sounded like fireworks. When I looked outside my cabin window, I actually saw fireworks. I also saw a group of teenagers playing with bottle rockets, but I didn't think anything of it, so I never said anything to the teenagers.
After these crackling sounds woke you up, were you able to go back to sleep?
No. As I was about to lay back down, I heard a whistle and a pop. Around maybe 2 minutes later, I heard this loud explosion.
When I looked outside my cabin window, I saw that the cabin with the scouts in it was on fire.
What did you do when you saw the fire?
My first instinct was to make sure that the scouts were safe. I immediately ran inside the burning cabin trying to pull them out.
Were you able to save the scouts?
I was able to save Blaze and Adrian. When I went to get Sammy, there was this loud explosion that burned the left side of my body. By the time I pulled her out, it was just too late. Sammy had already passed away.
Ms. Smith, there's been some testimony about things you supposedly didn't do during this camping trip. Do you believe there's anything more you could have done to save Sammy Mallory?
Objection, relevance.
Your Honor, if I may, the plaintiff is alleging that Taylor Smith did not do everything within her power to save the scouts and to protect the scouts. The defendant should be afforded an opportunity to address these allegations.
Respond.
Your Honor, I do not believe this defendant's opinion on whether or not she did everything she could throughout the duration of this camping trip is relevant to today's case. Furthermore, it is an ultimate issue that should be reserved for the trier of fact to decide.
Last word.
Your Honor, I didn't ask whether there was something more that she could do, but rather she believes there's something more she could do.
I'm going to allow it overall.
You know, I've thought about this over and over again. I mean, I took every precaution beforehand. I don't think there was anything more I could have done. Although I saved 2 scouts, I only remember the one I couldn't save. Sammy.
Thank you. Your Honor, no further questions.
Thank you. Cross.
Yes, Your Honor. Good afternoon.
Good afternoon.
You testified that you were the sole scoutmaster for Troop 55 in July of 2016.
Yes, I was the scoutmaster for Troop 55.
So you planned this overnight camping trip to Camp Kindle.
Yes, after the parents had asked me to plan it.
And the truth is, you didn't bother to check and see if this trip was even allowed by the Wilderness Scouts.
No, it was approved by them.
Your Honor, may I approach the witness with an exhibit that's already been entered into evidence?
Sure.
May the record reflect I'm showing opposing counsel Exhibit 1 that has already been entered into evidence is Plaintiff's Exhibit 1.
Thank you.
Would you please read aloud for the members of the jury the third point under this policy, starting with multiple day, ending with prohibited?
Multiple day overnight camping trips are prohibited.
And this trip that you planned was a multiple day overnight camping trip, was it not?
Yes, but first, I've never seen this, and the multiple day overnight trip that I planned was approved by the Wilderness Scouts.
So as the scoutmaster of a troop for Wilderness Scouts, you've never seen the rules that they have?
No, I have seen the rules. I've just never seen this Wilderness Scout policy. I've never heard of it either.
Thank you, Ms. Smith. Now, you would agree with me that you asked no other parents to attend this camping trip as additional chaperones, correct?
No, I had gone on a trip before, and it was a chaperone for 3 scouts. Since there was only 3 scouts, I didn't need to ask anyone else to chaperone.
Now, Ms. Smith, you would agree with me that the night before you took off on this camping trip, you stayed up until 3 a.m. partying.
Yes, it was my friend's birthday. I stayed up late, so I decided to go to Camp Kindle later that afternoon the next day.
You didn't tell the parents about your 3 a.m. partying, did you?
No, but I planned us to leave later, so I didn't see a reason to. I had enough rest.
You trusted your judgment.
Well, yes, I knew I had enough rest.
But you didn't allow the parents to decide whether or not they trusted your judgment, correct?
I don't understand.
You didn't allow the parents to decide for themselves whether or not they trusted your judgment Because you didn't tell them that you were partying until 3 a.m. the night before this trip.
No, I wouldn't see a reason to tell them. We were leaving later and I slept perfectly fine. It was regular sleep hour.
Now, you would agree with me that you were aware of Blaze Thompson's fascination with fire.
Not exactly.
You were aware of her science fair project on the combustibility rate of mattresses when ignited with lighter fluid?
No, I've never been aware of this.
Well, you yourself were present for the Scout meeting when Blaze Thompson informed you of her love for fire, correct?
No.
This was particularly noteworthy to you previously, correct?
No, I'm sorry.
You received an email from Blaze Thompson's foster parents regarding her love for fire.
No, I never received an email from Blaze's foster parents.
Your Honor, may I approach the witness with an exhibit?
Yes.
May the record reflect I'm showing opposing counsel exhibit 6 for identification. Ms. Smith, I just handed you the email from Blaze Thompson's foster mother, Michelle Ridge, correct?
I believe that's what it says here.
And it's addressed to your email address, is it not?
No, this isn't my email.
It is not addressed to your email address?
No, this isn't my email, I'm sorry.
Now, you would agree with me that you testified about 2 perimeter checks that you did on this trip, correct?
Yes. I conducted my first perimeter check when we arrived at the campsite, and then my second right before going to bed.
But the truth is, you actually missed every item that could possibly be a hazard.
What hazardous items?
You missed matches, correct?
When I conducted my perimeter check, I didn't see any matches in the cabins.
Blaze Thompson testified about finding matches on the ground, did she not?
Objection, Your Honor, lack of personal knowledge. At the beginning of this trial, in the pre-trial motions, opposing counsel asked that the rule be invoked for all witnesses. We later clarified that there should be an exception for the 2 experts. However, there was no exception laid for the defendant or the plaintiff. Therefore, this witness cannot testify to what Blaze Thompson testified to.
Your Honor, may I respond?
Yeah.
As in all proceedings, both party opponents would be present throughout the duration of the trial, therefore she could testify to what other witnesses have previously testified.
Of course, yeah. Overall.
Blaze Thompson testified about the matches she found on the ground, correct?
Yes, but she never said where, and when I looked in the cabins, I didn't see any matches.
Well, Adrian Sutler testified about lighter fluid he found in his cabin, correct?
I'm not sure.
You missed lighter fluid on these multiple perimeter checks.
I didn't see any lighter fluid when I looked inside the cabins in both of my perimeter checks.
You also missed a portable grill that made its way into the cabin of 3 minors, correct?
I never saw a portable grill when I checked the cabins.
Blaze Thompson brought this portable grill onto this camping trip, right?
Well, if Blaze brought the portable grill and it was in her bags, I wouldn't have seen it.
Now, you would agree with me that you are trained in CPR,
Yes, I am.
but you didn't one time attempt CPR on Sammy Mallory on July 5th.
No, when I had taken Sammy out of the cabin, she had already passed away, but I did conduct CPR on Blaze.
But you would agree with me that if you felt that Sammy Mallory had already passed away, you would have had nothing to lose by attempting this life-saving device on her at that time.
She had already passed away.
Now, Ms. Smith, you would agree with me that you were interviewed on scene the night of this incident.
Yes, I was.
And what had happened on July 5th was fresh in your mind because it was only a few minutes later that you were interviewed, correct?
Yes, that is correct.
And the truth is, when you were interviewed, you made no mention of fireworks or teenagers at all.
No, I was just thinking about Adrian, Blaze, and Sammy.
When you were asked how this fire started, you stated that you had no clue how this fire started, right?
No, I didn't know how the fire started until later on.
I'd like to talk to you about the teenagers you previously testified to. Now, these teenagers that were allegedly outside of your window, you didn't even bother to get up to check on your scouts when you heard them.
No, they were when I saw the teenagers, they were playing with bottle rockets, and bottle rockets are harmless, so I didn't think I would need to say something to the teenagers.
Still, these fireworks could absolutely be a danger or a hazard to your scouts, correct?
When I saw the teenagers, I didn't think it would be.
But you never got up to check on them or address the situation yourself on July 5th.
No, I never said anything to the teenagers.
Thank you, Your Honor. Nothing further at this time.
Direct.
Yes, Your Honor. However, before I begin, I ask the timekeeper how much time has been expended on direct examination.
21 minutes, 57 seconds.
You may proceed.
Ms. Smith, I want to talk to you about some things that were brought up in cross-examination. Did you ever specifically prohibit parents from attending the trip to Camp Kindle?
No, I never did that. If a parent would want to go on the trip, they could just tell me.
If a parent did want to go on a trip, would you have allowed them to attend it?
Of course.
It was also brought up on cross-examination some items that Blaze had. Did any of the scouts ever tell you that Blaze had matches?
No, none of the scouts told me that Blaze had any matches.
Did any of the scouts ever tell you that Blaze had campsite fuel?
No, I was never made aware that Blaze had campsite fuel.
Did any of the scouts ever tell you that Blaze had a portable grill?
No, I was never made aware of this.
If you had known, or if you had been told that Blaze was in possession of these items, what would you have done?
I would have immediately confiscated all of these items from Blaze if I was aware.
Thank you. Your Honor, no further questions.
Thank you, ma'am. Any additional witnesses for the defense?
No, Your Honor. This time, the defense rests.
Plaintiff ready for a closing argument?
Yes, Your Honor. Before I begin my closing argument, may I reserve any remaining time I may have up to 1 minute for a brief rebuttal argument?
Sure.
Thank you, Your Honor. May it please the court?
You may proceed.
Counsel. Members of the jury. A scout is always prepared. A scout is always prepared. These 5 words serve as a motto for many Boy and Girl Scout organizations across the country. That's because these organizations understand the importance of always being prepared. That's why my client, Frances Mallory, felt comfortable sending her daughter on an overnight camping trip with this defendant on July 5th of 2016. She thought she would be prepared. Now, in a few moments, Judge Jewett is going to read you your jury instructions and send you into the jury deliberation room. He's going to tell you that as the plaintiff, we carry what's called the burden of proof in today's case. This simply means we must prove to you by the greater weight of today's evidence that it was this defendant's negligence that led to the wrongful death of Sammy Mallory. So what does all of that mean? Judge Jewett will tell you that negligence simply means this defendant failed to do things that a reasonably careful person would have done when supervising children. We have to prove that it's reasonable that Sammy Mallory would be alive today had it not been for this defendant's recklessness and carelessness. So how did we meet our burden 2 here today? By the witnesses that took the stand before you and the evidence you've had an opportunity to see and hear. You heard testimony today about a 3 a.m. party that this defendant attended the night before this camping trip, and how this exhaustion certainly could have caused her to miss the items that Adrian Sutler and Blaze Thompson testified to you about today that were hazards. This defendant missed matches, canisters of lighter fluid, and a portable grill that all made their way into the cabin of 3 minors unattended. So matches, lighter fluid, a grill. Is it really any surprise that Blaze Thompson started the fire that killed Sammy Mallory? Investigator Sloan testified to you about the V-shaped point of origin that scientifically proves that this fire started inside this cabin on July 5th. He specifically checked for evidence of an electric fire or a fire that could have started because of fireworks, and there was simply no gunpowder present that would have indicated either of these possibilities. So why is it that you heard so much about fireworks in today's case? Well, because this defendant needed a scapegoat. You heard testimony that when she was interviewed on scene the night of the incident by a reporter, she made no mention of mystery teenagers or loud fireworks going off in the middle of the night. In fact, the only thing she did have to say was that she had no idea how this fire started. It was only after this lawsuit was filed and an expert was hired for $30,000 that she began storytelling about mystery teenagers being to blame for the death of Sammy Mallory and not her own negligence. Now, the real issue with this defendant's story in today's case is that even if it were true, she is simply just as negligent. She testified to you that when she allegedly heard these mystery teenagers outside of her cabin window, she didn't even bother to get up and check on her scouts like a reasonable person would have. That, members of the jury, is the definition of negligence. Now, you have heard testimony today that this defendant did rush into that cabin and save 2 of the 3 scouts on that night. It is so important that you understand that as the plaintiff, we applaud her for leaping into action on that night. However, being reactive is not the same as being proactive. There wouldn't have been a fire for her to run into if she had been prepared leading up to this trip. The bottom line in today's case is that if this defendant had followed the rules of the Wilderness Scouts, there wouldn't have been an overnight camping trip at all. If this defendant hadn't stayed out partying until 3 a.m. the night before this trip, she would not have missed matches and lighter fluid evident to her scouts. And if this defendant hadn't been so distracted on her phone or preoccupied, then she would not have missed a large portable grill making its way into the cabin of 3 minors unsupervised. In a few moments, when Judge Jewett sends you into the jury deliberation room, please remember the words that came out of this defendant's mouth prior to this trip. Do not worry. I take full responsibility for these scouts, and nothing will happen to them on my watch. When you make your decision in today's case, we only ask that you do what the defendant herself has asked you to do. Hold her responsible for the lives of the children she took on a camping trip on July 5th. Find her liable for the death of a scout she should have been prepared enough to prevent. Thank you.
Thank you, counsel. Defense?
Yes, Your Honor. May I proceed?
You may.
There are no words that can express the grief that Frances Mallory is experiencing. Grief and sympathy are powerful emotions. So we understand the plaintiff's need to find someone to blame. You may be sitting here feeling that same need, and the easiest thing to do would be to give in to that sympathy. However, I'm not asking you to make the easy decision. I'm asking you to make the right decision, the just decision, the decision supported by the evidence. And what has the evidence shown? The evidence has shown that while the plaintiff may be able to control the sympathy, they cannot control the evidence. And the evidence simply does not support the plaintiff's case. Now, with that said, the plaintiff is the one who has the burden of proof. You see, that burden rests right here. We, as the defense, didn't have to prove anything. Nevertheless, we have presented testimony that shows that Taylor Smith is not liable. You heard the testimony of Chief Bailey Burns. As we told you in our opening, Chief Burns actually taught the plaintiff's expert and has substantially more experience within the field of fire investigations. Chief Burns explained that there was no evidence supporting the opinion that the fire started within the cabin, and the burn patterns on the walls support the conclusion that the fire started on the roof of the cabin. Blaze Thompson explained what actually happened during the camping trip. Blaze described the teenagers she saw, the fireworks they were shooting off, and how right before the fire started, she saw those same fireworks being shot into the sky. This supports Chief Burns' theory that the fire would have started on the roof, which was made of dry palm leaf overlay. Finally, Taylor Smith took the stand and told you her side of the story. Taylor discussed the numerous safety precautions she took while on the camping trip, including the 2 perimeter checks to make sure that the scouts were kept safe. But despite her best efforts, Taylor could not stop the fire. But her true character was how she reacted after the fire started. Taylor, without any regard for her own safety, rushed inside the cabin to save the scouts. Taylor saved Adrian Sutler, and Taylor saved Blaze Thompson. But she could not save Sammy Mallory. Now, let's look at what the plaintiff had to establish in order to prove their case. They had to prove that the defendant had a duty, breached that duty, and that this breach was the proximate cause of Sammy Mallory's death. They haven't proven all of these elements. Let's look at the evidence presented by the plaintiff. They want to tie their case together under the pretense that a scout is always prepared. Absolutely. And so was Taylor Smith. Adrian Sutler told you himself about the numerous items, brochures, and packets that Taylor Smith provided to the scouts. Taylor Smith was prepared before the trip. Frances Mallory explained the liability waiver that she signed releasing the defendant from all liability. Just another preparation that Taylor Smith took to ensure the safety of the scouts. But sometimes, just sometimes, there are things that we can never prepare for. There was no way that Taylor Smith could have expected fireworks being shot by teenagers to start the fire on the cabin. But what did she do, even though she wasn't able to prepare for this? She ran inside the cabin, saving not 1, but 2 scouts during the trip. And she tried to save Sammy Mallory. She couldn't. Members of the jury, while the plaintiff may be able to control the sympathy that you're feeling right now, our sympathy does not change the fact that they can't prove their case. They cannot control the evidence, and the evidence simply does not support the plaintiff's case. Find Taylor Smith not liable in this case. Thank you.
Thank you, counsel. Rebuttal?
Yes, Your Honor, briefly. May it please the court?
You may proceed.
A prohibited trip, a portable grill, a 3 a.m. party, matches, and lighter fluid. No grief, no sympathy, only evidence. Thank you.
Thank you, counsel. Anything else that we need to take up from the plaintiff before we close?
No, Your Honor.
Defense?
No, Your Honor.
How about a big hand for the competitor? And just for information's sake, there is 6 scoring judges as well as myself, 7. I know there's more than that in the box. We have 7 total. All right, thank you guys. See you next year.